Judge, maybe we approach with Mr. Robinson's case?
Yes.
The probation just printed out for withdrawal. Case number.
Did you know qualify for Robinson?
No, I don't. Okay. All right, so y'all were set for a contested.
Well, it was, I don't think it was a true contested. It was one of those where we needed more time. Your Honor, you said that you're gonna set it for a contested, and if it ends up being contested, we are great. If not,
That's completely correct, Your Honor.
Yeah.
We were able to provide documentation in the meantime, which helped alleviated the alleged #1 offense.
All right, and so,
this is on the agreement, Your Honor, that the defendant's probation would be altered and amended to add a cognitive behavior.
all right, probation, do you think this is appropriate?
Yes, Judge.
How long is that cognitive behavioral course?
Judge. I want to say it's 20 weeks. 1 second.
And is there any need for any no contact orders?
10 weeks long, and it's 20 hours, so 2 hours per week for 10 weeks. And I believe there's already a no contact order in place.
All right, is there anything else needed?
No, Judge.
Nothing.
Is there anything else you need from the court
No, ma'am.
to be successful?
No, I've been doing a good job.
All right, so you need to continue doing that, okay?
Thank you.
All right, thank you.
Thank you, Your Honor.
Thank you. Your excuse.
Okay.
You too.
All right.
Ladies, all the way to the front, second row. Make sure there's a chair at the end.
Megan?
Your Honor, may we approach briefly? This is Courtney. She is our intern.
Hello, Courtney. So are you in law school or what are you doing?
Yes, 3L at St. Mary's.
Oh my gosh.
So she's got her bar card.
Ooh,
Yes.
that's when I got my bar.
Thank you.
But come by anytime. Who's ready?
Yes, ma'am, I have our code, page 3, 5 down.
Rosalind Torres.
Okay, so that's the interpreter. Norma wants me to do the interpreter first.
All right.
The interpreter here.
Sure.
And then.
Good morning, Your Honor. How are you?
And the interpreter is for page 1, 2 down. Mr. Rocha,
All right, Belara.
can we call you next because the interpreter is here and she could rather.
All right, hello.
I'm so sorry.
Sure,
Not
it's
my-
3 seconds, yeah.
I understand.
The interpreter, this is the interpreter.
No, Your Honor, it's
Oh,
not.
who's here with the interpreter? Yes. And then we'll take yours next.
And you have a seat in the audience, they'll call you right back up, sorry.
I understand. No problem.
Hey, 1 second. Sorry, you guys.
Okay, so today we're here for discovery. So are there any issues with discovery?
Your Honor, we are still waiting on some records. There were some new appointments that we had, or sorry, that she had this year. They're still being treated then, so we have ordered those records since it's happened. I do think we're on the road to a resolution. So if we could just maybe have a like deadline hearing.
All right, so how much time do y'all need for this?
It depends on the doctor who's analyzing the records, Judge.
Let's just say a week or two. That's
All right, so what I'll do, I'm gonna recall you back in 3 weeks. If they have the information before that time, they can just come in and put it on the docket.
Okay.
All right, Ms. Ferguson, what date?
March 12th.
All right, so we'll be back on March 12th. And if your attorney in the state wants you back sooner, they'll let me know. All right, thank you.
Thank you, Judge.
Have a good one. All right, Ms. Torres. Hello.
Good morning.
Good
Judge.
morning.
I've already put
All right, so where are we?
Judge, I believe that the defendant is gonna be a testifying witness in one of family violence cases, but family violence had their trial reset. So we're asking for a reset as well.
But when is she due?
It's a contested.
Soon.
Supposed to be.
We don't know. The what?
6 weeks. I'm already dilated.
All right, so who's the attorney on the contested?
Mr. Paul.
Mr. Who?
Paul.
All right,
He's supposed to, this was done last week, but he's in another trial, so. we got-
Lindsay. Can you come up? All All right, who's next?
Yes, ma'am. I have Louis Andrew Medina, page 6-3 down.
Morning, Your Honor. Mr. Medina is not present.
Oh,
He is disabled. He's a double amputee.
Mhm.
And the jail often has problems getting him here in the mornings. Asking if we can do a special setting for him for this PSI and an afternoon docket perhaps. I don't know.
where is he?
He's still at the jail, Judge. They don't have,
Are they able to, can he appear by Zoom?
Yeah.
All right, let's see if he can appear by Zoom.
Will that be this afternoon or this
No,
morning?
it's gonna happen now,
Happen now?
Yes.
Okay,
today, this morning.
very well. I've got to go check into 2 courts. I'll be back in about 20 minutes.
Okay, all right, thank you.
Thank you.
Devin Grisham,
Judge.
are y'all proceeding on the motion to revoke?
Yes, Judge, I have to insert of the appeal again.
All right, thank you. All right, the court is calling 2025 CR 010368 State versus Devin Grisham. Could I have parties announced?
Christopher Simpkins for the defense.
And are you Mr. Grisham?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Devin Roy Grisham who's placed on deferred adjudication in 2025 CR 010368 for the offense of theft of property less than $2,500 with 2 or more previous convictions on October 7, 2025 for a period of 2 years? Is that you?
Yes, ma'am, it is.
All right, state.
Judge, will be proceeding on a. You're right. Judge, will be proceeding on violation condition number 1, specifically that on or about the 8th day of January 2026 in Bexar, Texas, the defendant, Devin Roy Grisham, committed the offense of theft of property in violation of condition number 1.
Do you plead to that true or not true?
True.
Judge, the recommended on.
Are you
will waive
proceeding on that? All right, any objection to the state's waivers?
No objections, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes,
Knowing that, do you still wish to plead true to violation of condition number 1?
yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Judge, the proposed agreement is to revoke the defendant, place him in the state jail for 8 months, and the state will be TICing cause number 2026 CR 001815.
All right, and is that a theft case?
It is, Judge.
All right.
And that is our agreement, Judge.
So the question becomes, why should I follow the agreement that y'all are saying y'all reached? Because he's on deferred for a theft case. And it was enhanced to a felony because he has previous theft. And now he's back and he has pled true to another theft case. Why shouldn't he receive 2 years? What's going on? Why is he committing thefts?
May I speak, Your Honor?
All right, Jonah, you want him to testify? right.
Yes, Mr. Bishop would like to speak, so.
You want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Devin Grisham, ma'am.
All right, so why is this happening?
Well, I was homeless, ma'am, so it doesn't give me the right to, to take anything, it's not mine, but I was having a hard time with that, so I was trying to just get money to be able to get a room and not be on the street.
Why not Haven for Hope? Does Haven for Hope charge?
We had him check into that, Judge, and he.
That's what I actually, 2 days ago, ma'am, I just got, approved to.
But no, that was 2 days ago. This offense is the offense that you pled true to was January 8, 2026. So you're telling me that you were homeless and that's why you were stealing. So why didn't you do Haven for Hope before January 8, 2026?
I should.
And did you contact probation and tell them you were having issues?
Yes, ma'am. I was checking. with probation.
No. Did you contact probation and tell them you were having issues with being homeless and what was going on in your life? Because they're here to help you.
No.
Did you do anything on probation?
Yes, ma'am. I was
What did you
checking
do?
with him. I had gotten started with, he got me set up with classes. We had just, me and my probation officer, I'd just seen him like a day before I got arrested. And started, to get things set up.
But I mean, He's been on probation since October 7th, 2025. What does he mean?
Judge, I believe we tried to get him into the felony drug court.
Mhm.
They found that he didn't meet the criteria.
Mhm.
And so I believe he'd been held. Okay, the screening on that, I believe that would have been the most successful route for him.
Any questions?
No question, Judge.
Probation, what are you all recommending?
I believe it was ISF.
Recommended listed on the court summary indicates upon disposition of the pending case of main conditions for local ISF, followed by ISP. He was not accepted into felony drug court, judge, due to him not meeting the criteria for substance dependence. Probation met with him one time, and then he was rearrested 3 months after being granted for this same offense.
All right, I'm gonna give you a choice. These are your only two choices. There are no other choices. Do you understand?
Yes, ma'am.
First choice, I will revoke you. I'll sentence you to 1 year at the state jail facility. Second choice, I will continue you. We'll try to work with you. I say we, probation will, but you're gonna be going to ISF.
That's that 90-day program we just.
All right.
Well, here's the thing. You know yourself better than I do, better than your attorney does, better than probation does. If you want help, I will continue you. If you don't, I'll sentence you to a year in the state jail facility. With a year in the state jail facility, you receive credit for any time that you've been in custody on this case. Otherwise, you're going to be transferred to ISF. And then hopefully, you'll be better able to communicate with probation. So which do you prefer?
Um,
I'm looking right now.
the year state gentleman.
Okay. Are you waiving your right to appeal?
Yes.
All right, the court then will revoke, find you guilty, sentence you to 1 year in the state jail facility, give you credit for any time served. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. I have no jurisdiction to force them to place you in the program. You'll have to request it as well, but it should help you with whatever issues you may be experiencing. There's to be no contact with Quick Trip or Walmart. And no unsupervised contact with minors. Taking consideration 2026 CR 001815. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You're gonna have to start making better choices. If everybody who didn't have money stole, where would we be as a society, right? There are plenty of places that can help you. Excuse me. There are plenty of places that can help you. There's Haven for Hope. There's the Salvation Army. If you can't find some place when you're released, if I'm still here, you come back here and I will pick up the phone to call somebody to help you and give you access to programs, all right? All right, good luck to you, okay?
Thank you, Judge.
You're welcome.
Yeah, sir. Come on this way.
Is this Harper?
Put you all the way to the end.
Yes.
Who's down Harper?
Gerald. Oh, yeah.
What's up?
Hello,
Good morning.
good morning. Yes, so,
He's in TDC.
yeah, there's supposed to be a bench warrant
Yeah.
that was done. It was supposed to be done on February 2nd. How long is this bench warrant taking?
I checked this morning, he's still in Garza West. Like he showed up as an active inmate in Garza West. He wouldn't show up if he wasn't.
All right, recall this for the first week in March. All right, we'll see you back on March 5th.
Thank you.
You're welcome. All right, Jason Montez. Are you all ready to proceed on the MTR?
Yes, Judge.
Hello. Court is calling 2024 CR 5800 State versus Jason Montez. Can I have parties announced for the record?
State.
Christopher Simpkins for the defense.
And are you Mr. Montez? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it?
Yes, ma'am.
Are you the,
I don't mean to interrupt you. The state is saying that they're gonna withdraw this. So
Okay.
I just need a moment to talk to.
all right, thank you. All right, just step back, okay.
One of the twins, right back where you were before.
So what is happening with her?
Judge, the new number one was
Dismissed
mid,
for insufficient evidence, but we're going to withdraw and amend. It looks like there was previous,
DDRF?
no, not DDRF, but he was referred to the drug court. They refused him because of lack capacity, but we're just going to withdraw and amend. Follow recommendation for mental health initiative, do a diagnosis outpatient, and a re-referral to felony drug court.
Right, so what happened to the DDRF thing?
he did not meet criteria.
Okay,
It was capacity.
okay, all right, so I'm gonna sign the motion to withdraw, alter and amend your conditions to go to felony drug court. You're gonna remain in custody till they interview you. Just be honest with them. And make sure that you stay in touch with probation, okay? And no more face tattoos. Okay, all right, thank you. Lily Herrera,
Page 1, 3 down.
all right, hello.
I-
Is there an application in this?
Yes, ma'am.
Okay. Probation, there's an application. Court is calling 2025 CR 006045 State versus Lily Herrera. Can I have parties announced?
Lindsay Shaw for Ms. Herrera.
And are you Ms. Herrera?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Herrera, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Right, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, Ms. Herrera, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of controlled substance penalty group 2, 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? I'm sorry. Did you intend to give up the right to jury trial, the right to cross-examine witnesses, and the right to remain silent? All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right. According to the plea, there's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 120 hours community service restitution, the MRT, and the DOEP course. You understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor, so y'all proceed to exhibit 1 and all.
No objection.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Only, Judge, that she does live in Corpus Christi, so we ask that her probation be transferred to Nueces County.
Okay. All right, do you have any children?
Yes.
What are their ages?
18, 14, 11.
All right, do they live with you or someone else?
They live with me.
All right, who are they living with now?
My mother.
All right. Is there a child protective services case involved with this? And does your mom live with you?
Yes.
Okay.
She does have support here with her. Her boyfriend and her grandmother are here in court.
Okay. Thank you. So how long were you in Fair County before this incident?
Just 2 weeks.
Okay. And who is the Leslie person who was in the vehicle?
It was her and hers. But
Sorry, what?
There were hers.
No, I mean, who is she to you?
Nobody.
Okay. And was that her vehicle you were driving?
No, it's mine.
Okay. And what were you doing at the detention facility?
I was taking her to go see her boyfriend.
So it's Dominguez State Jail. Yes, whenever you go onto prison property, they
I
will
didn't-
search the vehicle.
I didn't-
Okay. And so, and I always ask questions because I'm trying to figure out what conditions are appropriate for people. So when you were driving her to Dominguez, your children were in Corpus? They were here?
No, they were in Corpus, my mother.
Okay. How far did you go in school?
11.
All right. So what do you do for employment?
I was a provider.
All right. So in this court, you know, I don't allow people to be home healthcare providers.
Been there for 2 years.
Okay. So, other than being a home healthcare provider, do you have any dreams, goals, hopes, ambitions?
Well, I'm gonna look for a new job. That most definitely.
But I mean, what's your dream job?
If I could build up my credit, I could like invest in like homes, trailers, so I can.
All right, this is what the court is going to do. The court will transfer to Nueces County. There's to be no unsupervised contact with minors. 3 years deferred adjudication. No contact with Leslie Silguero, Silguero. There's to be 120 hours. All right, you have me, Obashan?
Judge, transferred to Lake County, no unsupervised contact with minors, no contact with Leslie.
Silguero, Silguero. 3 years deferred adjudication. 120 hours of community service hours. I'm going to require parenting classes. Once the parenting classes are complete, the 20 hours will be deemed satisfied. You can obtain your GED or some sort of trade school certification. If you do that, then the remaining of the 100 hours will be deemed satisfied. There's to be regular reporting by Zoom or in person, regular random UAs, the MRT course, DOEP. And probation, I don't know if they do field visits there, but if they do field visits 1 time per month for 6 months. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No.
All right. Did you review trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. You have children who are depending on you. The range of punishment for this offense, if a motion to revoke is filed, is anywhere from 2 to 10 years in prison. From here on out, everything you do, if you're not doing it for yourself, do it for your children. Be on the straight and narrow. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back here to me, okay?
Okay.
All right, good luck to you.
Thank you.
You're welcome. All right, who's here on Monreal? All right, court is calling 2025 CR 006058B State versus Roberto Monreal. Can I have parties announced?
Jason Goss for Mr. Monreal.
All right, so there's a motion to amend bond conditions to allow for travel. And then there's another motion asking that contact be allowed with a specific individual.
Well, I believe that
It's connected to this.
I don't think that order is the proper order. I think we're only, there is an additional motion that we have, but it's kind of a strange one. Pretrial has,
So are we hearing that today?
I think they had 2 different.
Okay, so are we, well, you can't tear it apart because
Oh.
they filed it some sort of way.
Oh, okay. Well, this is a different defendant, so it's not.
No, but I mean, they have to unstaple it because
I'm sorry.
they're filing it legally, however they're filing
Yes.
it.
Yes, ma'am. That would be a different defendant. So we're here on Roberto Monreal.
All right. Okay, you want to go through that? All right, so motion to travel. State, are you opposed?
It's not this time, and the reason for that is due to the charge not being alleged, and we do believe due to the father living in Arizona, that does present a flight risk, and so that's why we want.
My client's 18 years old. The prosecutor referenced the charge. It is a murder charge. This is a situation from the arrest warrant affidavit where that the court could see that there is a.
Oh, I don't have the arrest warrant affidavit in front
I
of me.
understand. I believe it's in the court's file. Usually it's filed as part
We're
of.
paperless,
Okay.
so I don't have
I
that.
understand.
That's okay.
If I could, since you referenced the charge itself, and I think the prosecutor will at least agree on the facts that there was a person who died, but that person was in the same car as my client.
Mhm.
So this was not a person he was basically participating in whatever my client was participating in. My client was not a shooter. My client did not have a gun. My client was not involved in that. Now, the only reason I say that for the court is that if considering the charge, that I think those facts are also important. But additionally, his father lives in Arizona. He's 18 years old. He would like to go visit his father. The court has already granted him travel previously in the past where he did travel and he came back. And
That was during Christmas holidays, right?
yes, Your Honor.
Okay.
He's shown the court that he is not a flight risk. He's 18. Like I said, he's 18. There's not really, he doesn't really have anywhere to go, but he would like to see his father. He hasn't been able to see his father since he's been arrested. And so that's why we're asking for that brief period to go to Arizona and to come back, and for that travel to be granted.
Judge, I will agree to a certain extent with Mr. Boston's rendition of the facts. It is a felony murder, so there's an underlying felony that was occurring at the time of the murder. And I will stipulate that this defendant was not charged as the principal. And if the court would like, I can produce a copy with the arrest warrant.
And we have no objection to that. If the
All right.
court wants that.
Let me see that. Mr. Monreal, who all lives in the household with your father?
It's just my father, Your Honor.
All right, court has reviewed B1 for purposes of this hearing. I'll hear final argument.
Yes, Your Honor, as the court has reviewed, the person who was deceased was the person that they're alleging was committing the robbery, shot by the alleged victim of the robbery. As the court can see, my client did not have a firearm, did not carry a firearm, and we're going to be litigating this case, but I just wanted the court to understand this. Because I know the court knows, but just to see the facts of this case, there's a difference between somebody actively committing violence by taking a gun, shooting a gun at a person. My client didn't do any of those things. And really what we're asking at this point is just to, on this motion, is to have him be able to visit his father. As I said, he is 18 years old, was 18 years old at the time of the commission of this offense. So he is a teenager, and we do think that it's important for him to see his father. We think that by the court giving him the opportunity the court has given him before, and him being able to take that opportunity and to do what he was supposed to do and what the court asked him to do and follow the rules of pretrial and the bond conditions this court has set upon him. We believe that he's shown the court that he can be trusted to go visit with his father and return. And we don't think that there's any information or evidence the state has provided that would not be the case.
Okay, this is what the court is going to do. Previously, the court allowed the defendant to travel December 22nd through the 27th, and that was to Denver with family. And are there any allegations that he violated any pretrial conditions while traveling there?
I understand that's when there's no still virus.
Okay. All right, this is what the court is going to do. The court will allow you to visit your father. I'll give you the same travel that I've given before, but it's for 5 days. That was the Christmas travel, and this will be for 5 days. So it's 5 days from March 7th. Are you leaving March 7th or a different date? All right, so you'll need to provide that information to pretrial services. So then your travel date that's on this motion, it says March 7th through March 15th. That's not the appropriate travel date?
I believe that it is the appropriate travel date, but as the court has limited that date, I don't know. I don't know necessarily how that would limit as far as where the 5 days are going to be at the end, or the 5 days are going to be starting from the 7th or coming back from the 15th. You see what I mean? And so it might be the 10th through the 11th through the 15th or the
All right,
7th
this
to
is what the
11th.
court is going to do. The court is going to grant the motion. You're allowed to travel to Phoenix, Arizona in the month of March 2026 for 5 days. There should be UA upon return. And you're to reside at the address that's given in the motion. Is there anything else?
Not for the defense on this motion. There is an issue I'd like to address with the court. I've talked to the district clerk, and they have not been able to. There's a letter his pretrial officer has written to the court. I think the court wanted a hearing based upon that letter. It had. I know, and they couldn't find it either. I don't know if probation might have access to it, but the basic issue is my client would like to apply to a trade school, and he asked his pretrial officer for permission to do that. She did not grant it. She wrote a letter to the court. The school would start in September.
All right, if somebody want to contract, who's the pretrial service officer? Yes.
Amanda Sings.
All right, Norma, see if she can zoom in. If you'll let the coordinator know who it is, and then we'll have her zoom in.
Sings.
Fine,
Yeah, Science.
Mega fine.
All right, just have a seat. She'll zoom in and we'll take up the matter.
Yes, thanks.
State, do you have any objection to taking up that matter now?
No.
Okay. Danny Rodriguez. All right, so where are we on the PTD?
It was accepted. He signed, prosecutor signed, I've signed, and we're just gonna turn it in.
All right, Ms. Ferguson, I need a PTD date.
19th, March 19th.
All right, just make sure you follow through on everything, okay? Good luck. Once you sign the reset form, you're excused. Angela Bowl. Counsel, is there an application?
There's not, Your Honor.
Okay. Probation, there's no application. Court is calling 2025 CR 014580 State versus Angela Ball. Can I have parties announced?
Daniel De La Garza for the defendant.
And are you Ms. Ball? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I'm sorry.
That's okay. Court will find that the state is in compliance with discovery. Ms. Ball, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Ms. Ball, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession. Oh, just one second. Oh, you're charged with manufacturing and delivering of a controlled substance penalty group 2 or 2A, 1 to 4 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call on the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
No, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Ball, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 2 years in the prison, and there's a $1,000 fine and no applications. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, she offers states exhibit 1 and not.
No objection.
State your excuse. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just, she takes responsibility.
All right, the court will sentence you to 2 years in the prison, give you credit for any time served. There's a $1,000 fine. Time and money will run concurrent. There's to be no contact with Austin Escamilla and Johnny Vasquez Jr. So do you want this to run concurrent with parole, or has that been addressed?
Please, it has not been addressed, but I would like it. Yes.
All right, concurrent with, let me see. The parole number is not in here, so you'll have to.
I'll either get it or I'll supplement it with the clerk.
All right, concurrent with parole sentence.
We'll do that today, Your Honor.
All right, and there's to be no residing in households with minors. And no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. How old are you?
Thanks, sir.
All right, so look, you're gonna have to start changing your ways. Otherwise, you're gonna find yourself spending the rest of your life at a prison or at jail. You understand? And here's the other thing. When you're doing these type of things, that's you building your happiness off somebody else's misery. You can't do that. No good will ever come of that, okay? All right, when you're released from prison, if you need help staying on the straight and narrow, if I'm still here, you come back. I'll help you find a place to help you, okay? All right, good luck to you. You're welcome.
Thank you very much, Your Honor.
You're welcome. Carl Robinson.
Present, Your Honor.
Hello.
Mr. Robinson refused to come over from the jail. He was set on yesterday's docket. Weird. This is our second, maybe third setting at the most. We are close to still negotiating for a plea. He was a little upset yesterday because some discovery documents he was looking at, he couldn't take back with him to the jail cell, to the jail, you know. Regardless, Judge, I'd like to get a reset for it, and I'm still talking to the state.
All right. Norma? Yes, sir. Set this in 2 weeks for a jury trial. And Deputy Laura, he'll need to be dressed. Now, can you do it on March 4th?
Judge, I'm gonna be out of the country March 9th through the 13th, so I don't think our trial is gonna be able to resolve in 48 hours.
You say March when?
March 9th through the 13th. I'll be out of,
Well, let's see what happens. Let's see where we are.
we can always try and
Yeah.
see where we're at.
All right, Norma, put it for March 4th.
Okay.
And I'll notate that you're supposed to be out of the country. Where are you gonna be?
My wife are going to Israel. If Trump doesn't bomb Iran,
Oh, okay. See, we know what may happen.
you know how that goes.
Okay.
Carl, okay. Maybe excuse, Judge?
Yes.
Thank you.
Christian Garza? All right, are there applications?
No, Judge.
And there's just a plea on one case?
Yes, Judge, TIC and the rest.
All right, the court is calling 2025 CR 0149939 State versus Christian Garza. Can I have parties announced?
Brandon Brennan for the state, John Pettis for defense.
And are you Mr. Garza? Okay. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Garza, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Judge will be proceeding solely on count one, waiving and abandoning the remaining counts.
Any
No objection.
objection?
No objections, Judge.
Mr. Garza, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
You're charged with aggravated robbery in count one. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and was, Judge.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Sorry?
Are you satisfied with the way you've been represented?
Yes, Judge.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, sir.
Okay, that's okay.
Yes, Judge. Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 8 years in the prison. State will take in consideration 2025 CR 011050 and 2025 CR 011063. If the court finds that a weapon was used in this case, then there will be an affirmative finding of a deadly weapon by the court. Did you understand?
Yes, Judge.
Is that the agreement, defense?
Yes.
State?
That is your agreement, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Judge.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest?
No problem.
State any evidence.
Judge, we have to state exhibit number 1, including all of its attachments.
No, Judge.
All right. And state you've spoken with the complainant?
We have, Judge.
Thank you. You may be excused.
Thank you.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We're asking for a reset for sentencing, Judge, just to allow him to get his affairs in order, and then
they changed so much. All right.
okay, Judge. I mean, doesn't seem like we have a choice.
Yeah. My hands are tied.
There's no legal reason, I guess.
Okay. So the court will find you guilty. The court will sentence you to 8 years in the prison, give you credit for any time served, take in consideration 2025 CR 011050 and 2025 CR 011083. And there's an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you. People on Roberto Monreal. All right, we're on the record in 2025 CR 006058B, State versus Roberto Monreal. Can I have parties announced?
Megan Galloway for the state.
Jason Goss for Mr. Monreal.
And are you Mr. Monreal?
Yes, Your Honor.
All right. The defense is requesting that he be allowed to apply to a trade certification or some type of electrical apprenticeship program. And we have the pretrial officer by Zoom. Any objection to the pretrial officer appearing by Zoom?
None from defense.
All right. So state, do you have any objection to the defendant being allowed to apply for this program?
Judge, I guess my objection would be if then he's going to be asking for partial to attend school. And the reason for that is because the magistrate in this case that wrote the warrant viewed the evidence, and I know Mr. Voss is, it's gonna be litigated at some point, however, judges are allowed to place conditions upon a defendant that is charged with a crime based on what they believe is for community safety. And so in this case, based on, and I would reoffer State's Exhibit B1, but what that represents to us is that the defendant was aware of and participated in the underlying felony. And I know they're contesting aspects of that. However, the law of parties provides that under state law, he is to be charged with the offense of murder. And so for those reasons, we are not in agreement.
Your Honor, if I could provide just a little bit more information to the court, the school is not set to start until September, but the issue, as the court probably knows, is that the application process has to go through and he has to either be accepted or not. We're just asking really for the first part. Obviously, if the school did start, I would agree with Ms. Galloway. We would be coming to the court and asking for permission to
Well,
attend.
don't you apply online?
No, no, it's, I have to go in person to apply.
Mhm. All right, and pretrial services is the only reason you're not allowing him to do this is because he's on full GPS?
That's correct, Judge.
Okay. All right, thank you so much. Do you all have any?
problem.
No, Your Honor.
All right, you can remain on to see what my ruling is going to be.
I appreciate it. Thank you.
Thank you. And where is the location for you to provide your application? All right, so the court needs that information before I'll even consider doing it.
It should be with the pretrial. I'll let my officer know.
All right, so the document I have before me, they were able to give it to me. They gave the name, but there's no address listed. So,
Is it in San Antonio?
Yes.
So it is in San Antonio.
I need the address for me to even consider doing it.
Your Honor, can I get the name of the place?
All right, if you all step back.
Yes, Your Honor.
All right, thank you so much, Ms. Sines. You can remain on, or either we'll send word to you what my final decision is. All right, thank you.
Okay.
All right, Rick Contreras. All right, is this a motion to revoke?
That's correct.
And are we proceeding on the motion? Mr. Cox, are we proceeding on the motion?
I think we reached an agreement that
Okay. All right, so we're proceeding on the MTR?
Yes, Judge.
All right. Court is calling 2021 CR 2910W State versus Rick Contreras. Can I have parties announced?
Megan Galloway for the state.
Cornelius Cox for the defendant.
And are you Mr. Contreras?
Yes, ma'am, I am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rick Anthony Contreras who was placed on deferred adjudication in 2021 CR 2910W for the offense of possession of a controlled substance? Let's go off the record. All right, we're back on the record. State?
Judge, at this time, we would ask for an oral motion to amend the motion to enter adjudication of guilt and revoke community supervision. Regarding the first paragraph, the predicate offense should read as possession of a controlled substance 4 to 200 grams PPY.
Right, any objection?
Oh, yes.
All right. Are you the same Rick Anthony Contreras who's placed on deferred adjudication in 2021 CR 2910W for the offense of possession of controlled substance penalty group 2, 4 to 200 grams on March 30th, 2021 for a period of 4 years and extended for a total of 2? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 2 on or about the 13th day of January 2026 in Bear County, Texas. The defendant, Rick Anthony Contreras, did their failed to submit to drug testing in violation of condition number.
How do you plead to that? True or not true?
True.
People waive and abandon their.
Okay.
All right. Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is to deny the state's motion and alter and amend the condition for safety along with.
All right. And that's the post for.
Yes, Sean. That's it.
Here's the thing. I do not know if you will be able to successfully complete this because this is not your first motion to revoke. And we're here for the same violation. So I'm going to give you a choice. There are no other choices. These are your only choices. 1, I will revoke you and I will sentence you to 3 years in the prison, or either I will continue you. And when I continue you, I'm going to extend you and you're going to safety and you're going to remain in custody until transferred to safety. Which do you prefer?
Well, counter proposal. In terms of, my client, he's willing and wanting to go through the safety program.
Okay.
And so that's not an issue. We agree that's not an issue. And his situation, Judge, is, you can see, it's been a constant struggle with the drugs. But it's not a situation where he just given up on that struggle. He's been in the fight, and although a lot of times the drugs have an upper hand, but he's still fighting the fight.
Yeah. So I mean, that's why I'm giving him 2 choices.
Right. So I understand, well, the prison, that's always the case. Not a solution, but a choice. What we would ask the court to do is allow him to go to the safety program.
Oh, no.
When he comes back, then the court has some other assessments in terms of what he needs. Then I would prefer the court make a decision. Then the court would have an opportunity to get an update from the program, how well he's doing, and get an opportunity to see.
Oh, no. I'm just asking, if you want today, I will revoke you and sentence you to 3 years in the prison, or I'll deny the motion and you can go to safety. Those are your 2 choices.
I think we agreed on the safety.
No, I mean, here's the thing. You know yourself better than I do.
Yes, ma'am.
Better than anyone else. So that's why I'm giving you the 2 choices. I am hoping that you choose safety. I'm hoping that you'll be successful. But I'm just saying, based upon this is not the first time that you've been before me for a violation of number 2. And I've added conditions to help you. I just don't know if you will be successful. So therefore, I'm giving you 2 choices. 3 years in prison, or either you remain in custody for transfer to safety. Which do you prefer?
Safety.
Okay. All right. Ms. Abrams, 2 will be true. Deny the motion, alternate amend conditions. He's to remain in custody for transfer to safety. Or if felony drug court accepts him, he can go to felony drug court. That's it.
Okay, I already fell in the first one.
Oh, it's completely up to them. I have no control over your being placed in the program, but yes.
Judge, I don't think felony drug court, is gonna accept him.
Oh.
And you can talk to her and she'll tell you why. All right.
That's fine.
Thank you.
Thank you very much, Judge.
Thank you.
In order for him to be on, go to safety, he has to have 2 years remaining on probation. At this point, he only has a year remaining.
All right, so we're gonna have to extend him. And extend him for the 2 years.
Here,
Yes. Sir, you're gonna be extended for 2 years because of the program.
If he completes successfully, would the
Oh.
court entertain early termination?
Always am available to entertain any motions that are brought before me.
Appreciate it. That's refreshing. Thank you.
All right, thank you. Yes.
Just wanted to return the letter, and I've written the address on there, so the court has the address.
All right. State on this Monreal matter. All right, and what date would this be?
I think at the time, he'll have to call and get the appointment scheduled, and we weren't gonna do that unless we knew that the court was.
All right, I will tell you this, the fact that I'm allowing you to apply for that doesn't mean that I'll allow you to attend. I haven't made up my mind on that, but I will not make a ruling on this until you give me a specific date and time. Okay?
Judge, would it be possible for him to pre-trial that day and then?
He has to give it to me because I have to make a ruling on it.
Yes, sir.
All right, thank you.
So just so I know.
And he can appear by Zoom.
He can appear by Zoom, or would we be required to file another motion or a different motion?
No.
Okay, thank you, Judge.
Marissa Gallardo. All right. Where we're in discovery, I know we had a warrant or something.
They did tender the search warrant, Judge. I'm happy to sign off on the discovery acknowledgement. I was given an offer of pretrial diversion, so I'm going to submit that application at the fourth floor today and just hoping for time for that process to occur.
All right, I need a PTD date.
March 19th.
All right, so y'all just make sure everything is filed with PTD, the application, before you come back on March 19th.
Will do, Judge.
Once you sign that, your excuse.
Thank you, Judge.
All right, thank you. Is there an application? Probation, there's an application.
Already told her, Judge.
Okay, thank you. And is there just a plea on one?
Correct. There should be 2 dismissed tendered for you.
All right, court is calling 2025 CR 013596 State versus Tory House. Can I have parties announced?
We're underway for Mr. House.
And are you Mr. House?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. House, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
See, this proceeding on count 1 paragraph F, Your Honor, we will waive the remaining paragraphs.
Any objection?
No objection, Your Honor.
I'm so sorry, state. If you can write another dismissal, because they like to sign their own, I should say.
Also give it to Judge Key.
Okay, thank
Got
you.
it.
All right, Mr. House, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, and count 1F, you're charged with burglary of a building. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Sir.
if I were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. House, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1, paragraph F. There's a $1,200 fine. State is recommending deferred adjudication. They're taking in consideration 2025 CR 013595, 2025 CC 015356, and there's to be restitution, if any, to the following
Yes, ma'am.
defense.
Yes, Your Honor.
State.
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation, 120 hours of community service restitution, the anti-theft course, a felony drug court referral, and if not accepted, safe P. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 1, paragraph F, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 in all.
No objections.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call on the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Just that the court follow our agreement.
All right. So do you have any children?
No.
Do you have any family support?
Yes.
They are present in the courtroom, Your Honor.
Okay. How far did you go in school?
College.
Okay. So how did you get on this path?
Just being around the wrong people and just not following like the path that I was on out of school.
Well, you know, when people come before me and they say they're around the wrong people, like the other suspect in this case, if I were to talk to him,
Right.
he would say, I'm around the wrong people. And I'd say, who would that be? And he'd say you.
Right.
So how old are you?
I'm 33.
All right. And so how long have you been using?
For like 5 years.
And what were you using?
Right.
Okay. All right. So it's obvious that you're going to need some help with drug addiction. And is his family members going to allow him to live with them if they?
That was part of the issue that we were discussing, Your Honor, hence why we, after conferring with the state, they want him to go to felony drug court, and if he's not accepted, to go to safe P. And upon his release, if he's successful on this rehab, then they would consider him being able to live
All
with
right.
his mother.
So his mom is here.
Yes, Your Honor.
Can I speak with her?
Sure.
All right. If she'll come up.
Might have difficulty. She is in a wheelchair.
Hello. All right, so here's the thing. I'm going to grant his application for probation. But when people have drug addictions, it has to be a global support system, right? Probation can't help him if you're not helping him. So that means if he does come to stay with you, you're going to have to lay down the law and there's going to have to be consequences. And if he's not following those, you're going to have to pick up the phone and call probation. Your attorney will tell you if somebody is on probation and they call probation and say, hey, I think I'm going to use, what's going to end up happening in this court? I'm going to set it for a compliance hearing. They're going to come in and we're going to see what help we can give them. But we can't have people disappearing and not reporting, and then they don't report and say, well, I got afraid, so I never showed back up, because that limits options.
That's the circle we've been in.
All right.
We've done rehab. We've tried rehab.
Okay.
And I've been in the circle with my son. And that's why I was talking with his attorney, explaining that just throwing him back out there, I don't think we'll be setting him up for success.
Okay.
To be truthfully honest. So when they said inpatient treatment, I think that would be the best.
All right. So
I'm there to support. I'm 1,000% for my children, but I don't want to see him come right back up in front of you.
but you're strong enough for him to have consequences for actions.
Yes.
All right. So I can tell you what I'm going to do. I am going to refer him to felony drug court, and you'll need to talk to them to see if they have room for him.
I already talked to Rashad about that, so it should be good.
And then what I'll do is, if he's accepted a felony drug court, I am going to put him on GPS with a curfew. And so we'll know where he is.
Would the court consider waiving the GPS fees just because of his
yeah.
indigency status?
Yes, the fees will be waived, but that's so we'll know him. Because right now he's going to have to build up his level of trust with probation, and felony drug court makes them build up the level of trust before he's allowed to do other things. All right. Other than the drug treatment, is there anything else that he needs?
No, I think maybe mental health.
Okay. A felony drug court, they have a dual diagnosis program, so they'll address any mental health issues with any substance abuse.
Yes, and I think between those two, he'd be smart. Academic scholarship to Texas Tech.
Okay.
Smart kid.
Mm-hmm.
Youth orchestra.
Oh, wow.
Youth orchestra. He can play violin, viola, cello, bass.
Oh, wow.
He was very talented. He got mixed up with the wrong people, and I couldn't get him back.
All right. Well, we're going to try to get him back on the right track.
He's a good kid. He really is.
Okay.
It's down in there somewhere. We just need to find him again.
Okay. So I'm going to grant his motion, and we're going to see about getting him some treatment. So if felony drug court doesn't accept him, that means he'll be going into an inpatient treatment. And even if he's accepted in felony drug court, they'll set his conditions. So they may decide he still needs inpatient treatment as well. Okay.
Thank you so very much.
All right. You're welcome.
And just
Thank you.
Can you state your name for the record?
Yes, Vanessa Smith.
Okay.
Thank you.
All right. Thank you. And if you'll make sure she gives probation her information.
Sure, Your Honor.
All right, Mr. House. All right, so this is what I'm going to do. When's the last time you had any type of employment?
It's a couple of years.
Okay. We're going to do our best to get you back on track, all right? So I'm going to send you to 4 years deferred adjudication. There's to be a referral to felony drug court in custody. They'll probably be able to see you on Tuesday because it's late in the week. If not accepted, then SafeP. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home healthcare provider or with minors. Partial GPS for treatment. Waive GPS fees. Field visits 1 time per month until further notice. 120 hours of community service restitution. There's a $1,200 fine. That will be probated. Taking consideration 2025 CR 0135595, 2025 CC 015356. Restitution and no, if any, and no contact with the following. Successful. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, you're gonna have to do better. If you don't do it for yourself, do it for your mom. Get back into playing your instruments, okay? All right, good luck to you.
Thank you, Your Honor. Very brief,
Welcome.
please.
Yes.
Have a seat, sir.
All right, Robert Lopez.
Judge, I had made a note on the call sheet to move to the trial docket. The offer changed today, and really what Mr. Ochoa was just asking for a little bit more time so that he could talk it over with his family. It's a time offer. I didn't realize that by advancing it to trial past the deadline, that we would then maybe lose the ability to plea. So what I'd really be asking on behalf of Mr. Ochoa is if we could have a short reset for him to be able to communicate with his family before he makes the decision to sign for TBC.
All right, and how old are you, sir?
39.
39?
Yes.
All right, Norma, recall this for tomorrow.
Tomorrow?
Mm-hmm.
There's no way you can give me a month so I could just teach you my key.
No,
Oh,
no. We'll recall it for tomorrow, and if there's no agreement that is reached, your next setting will be jury trial date. All right, thank you.
Thank you, Judge.
Have a seat, sir.
All right, Stevie Stokes. So what are we doing today with Mr. Stokes?
A true agreed recommendation to the court. We've gone over the MTR again, so I think we're all on the same page now.
Okay. All right. Court is calling 2023 CR 7159, State versus Stevie Ray Stokes. Can I have parties announced?
Kelly Piddle for Mr. Stokes.
And are you Mr. Stokes? Did you review the motion to revoke community supervision with your attorney, and did you understand it? Are you the same Stevie Ray Stokes who was placed on community supervision in 2023 CR 7159 for the offense of abandonment or endangering a child by placing the child in imminent danger of bodily injury on September 9th, 2024 for a term of 8 years? Is that you?
yes.
All right, state.
Violating condition number 1, on or about the 5th day of January 2026 in Dare County, Texas. The defendant, Stevie Ray Stokes, committed the offense of unauthorized use of a vehicle in violation of condition number 1.
How do you plead to that? True or not true?
Violating condition number 2, on or about the 8th day of December 2025 in Dare County, Texas. The defendant, Stevie Ray Stokes, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or duly authorized agent of the court in violation of condition.
How do you plead to that?
State will waive the remaining allegations.
Any objection?
No objection.
Off the record for a moment. All right, and you're waiving the remaining violations?
No
No objections. All right, did you understand by pleading true to violations 1 and 2, the court could find it true, grant the motion, and sentence you up to 8 years in the prison?
Yes.
Knowing that, do you still wish to plead true to 1 and 2?
Yes, ma'am.
Court will find violations 1 and 2 true. Is there a proposed agreement?
This proposed agreement is to deny state's motion and alter and amend conditions, allowing for hold in jail. I amend for ISF, followed by ISP gaming unit supervision, as well as P-Suite QAs for 90 days of projects.
And just, that's local IFF.
Okay.
That's our understanding of the agreed recommendation.
All right. So has he done anything on probation?
Yes. I don't know what he's done, Judge. It's been a year. He's had to have done something.
Yeah.
Thank you. Can I have the court summary? Thank you.
Judge, Mr. Stokes completed the parenting class.
Mhm.
And has a total credit of $86 for his balance. A TAP evaluation was conducted on the 18th of December, and it recommended supportive outpatient treatment. But it looks like there just seems to be a struggle here.
All right. So,
Mr. Stokes was employed. He had a good job. The job was at a distance that made it difficult for him to take the bus. So he made the poor choice of buying a vehicle without a title. And we've talked about that. We've talked about how you don't ever buy something without getting a title to something first, because then you end up in situations like this. So he understands that now, and he apologized to the court and apologized to complainant for being in this situation. We asked the court to follow the recommendation.
all right, I'm going to give you a choice. These are your only two choices. Don't ask for a third. Number one, I can revoke you and I'll sentence you to 3 years in the prison. Or I'll deny the motion, alternate amend conditions to local ISF and ISP gang.
Can we talk for?
Sure.
Can we talk over there?
Sure, okay.
Okay, thanks.
All right. So what do you prefer?
Just take the 3 years if probation, if I'm done with probation, is that?
You'll go to prison
Sentenced to prison.
and
3 years.
so if you can do a trial court certification.
Yes, do it right now.
So you want the 3 years?
I mean, I don't know what ISF is, you know. I just don't.
ISF, you will be in custody. They will work with you so that you can make better decisions. It's supposed to work with you cognitively so that you can think through any decisions that you are making.
And ISF is 90 days?
Yes.
I take 90 days, ISF.
Okay. All right. The court is finding 1 and 2 true. The court will follow your agreement, deny the motion, alter and amend to include ISF, local, ISP, the gang evaluation, and there's to be no residing in households with minors. Probation, is there anything else? All right. Thank you.
Thank you, Judge.
You're welcome.